WBCD
Mr. Chakraborty, we will give it after the two matters.
My lord, my lord.
একটু দেখি বের করেছো তুমি?
Item number 2. APM 85 of 2024.
I served a copy of application and appeal upon the counsel who appear before the appellate court.
Pass over, madam, but we have only 3 matters in the list. Where is your senior?
Very short time.
Item number 3. WBCD 15 of 2025.
Fresh, new matter, my lord.
You served?
No, my lord, service is not. Serve and come back.
They filed it yesterday.
Yes.
What is the matter about?
My lord, this matter, my lord, it concerns police personnel working in the fire brigade, my lord. There was certain compensatory allowance, my lord, which was given to them in 1979 under a circular. Now, subsequently, my lord, the central government decided, held up the administration for giving them this benefit without prior approval of the central government. And the benefit was withdrawn because they were getting some other benefits. So the central government said that you cannot give them both the benefits. And then, my lord, that was long series of litigation, my lord, representation, consideration, etc. And eventually, my lord, the CAT has held in their favor, saying that the benefit is required to be given to them as is given to other police personnel. But the administration's contention is, my lord, their job is different from that of regular police personnel, and therefore this allowance should not be given to them.
But they are attached to fire department.
Fire department, but the allowance which has been withdrawn from them is being given to other police personnel in the Andaman and Nicobar police. So administration is contending that they get certain exclusive allowances which the other police personnel don't get, and therefore they should not be given the benefit. And the central government has in fact passed strictures on the administration for giving this benefit to them. Service is not done, my lord.
The double bonanza cannot be done.
Yes, my lord. That is.
এটা তো পুলিশ পার্সোনাল, ওদের তো কোনো দোষ নেই, ওদের তো ডেপুট করেছে। Mr. Chakraborty, learned senior advocate appearing for the this.
This matter for extension of validity order which was passed on 6th of June. I pray as the matter is pending before the Honorable Apex Court. Tentative date is fixed on 15th of April. This order is.
You're for the respondent.
I'm for the respondent. I'm not standing on the way. Let it be been accepted.
The partition suit.
These are partitions. It was written,
You have filed your affidavit of service.
yes, there.
Ashok, affidavit of service as filed be kept on record. Stop. Please.
Item number one, WPCT 44 of 2024.
ইয়েতে কি লেগেছে? We have discussed the arguments as advanced. The disciplinary proceeding was initiated against the petitioner in the year 2000. For more than 2 decades, the petitioner had remained trapped in a purgatorial legal rigmarole, moving back and forth between the High Court, the respondents, and the learned tribunal. He has been out of employment for more than 24 years, which on its own merit is a matter of great suffering, agony, and ignominy. This is an appropriate case for this court to put an end to the already protracted legal proceedings. Taking into consideration the misconduct alleged, the petitioner should not be deprived of his terminal benefits, which is the sole source of his livelihood. In view of the discussion, we find that the punishment of dismissal imposed was too harsh in the facts and circumstances of the case, and to put a quietus to the issue, it would be appropriate to direct substitution of the punishment of dismissal. Since in a case where the original punishment is set aside only to be substantiated by a new punishment pursuant to an order of judicial review, then ordinarily such substituted punishment would relate back to the date of original punishment. The order of dismissal dated 24 June 2011 is accordingly set aside, and the respondents are directed to impose a punishment of reduction to a lower stage in a time scale of pay from the date of imposition of the punishment, 24 June 2011, till the date of his retirement without cumulative effect. The respondent shall reinstate the petitioner with continuity in service. In the totality of these facts and circumstances, it would not be proper for us to grant back wages to the petitioner for the period during which he has not worked. However, to serve the ends of justice, we direct the petitioner be provided notionally the benefit of continuity in service, not for the payment of back wages, for the period that he did not serve the organization, but for the purpose of retirement benefits like employers' contribution towards provident fund, payment of gratuity pension, and leave encashment. The entire exercise of payment of retirement dues, as indicated above, will be carried out by the respondents within a period of 2 months from the date of communication of this judgment. The order impugned in the appeal is accordingly set aside, and the appeal stands allowed to the extent indicated above. Now, the observations, the writ petition is disposed of.
Well,
WPA 166 of 2025.
Yes,
I am for the report.
where is Mr. Mishra? Have you seen him? You were not there yesterday. What is the matter? Tell us. Let him come. Dekhi.
It's electricity matter, my lord.
There is. Have you served upon Mr. Mishra?
Already, sir.
Yes. What is your matter?
So it has not searched the department, so I was not able to take the inspection.
What is the matter? Tell us now.
For grant of electricity.
For grant of electricity connection,
So it has to go to them.
But if let him serve. Why department is not considering, I have to explain before this honorable. Let him serve the department, what is the difficulty? Very long that this application has been filed.
Mr. Mishra, if I say you dispose it of, I am not saying that you grant connection.
Not dispose it of.
I will
All
say that you will consider, and if it is found that your prayer is to be accepted, then they will come, they will take the follow-up step.
my lord.
Will you be satisfied with that, or you have to go second round of litigation if they reject?
My lord,
But
okay.
it has to be served. Now he is also right. Why didn't you serve? You haven't sent the copy also.
I'm sending
Which is your application?
page number 13, my lord. This application dated 24/7/2024.
Hmm.
सर सर्विस तुमको किया ना मतलब सर्विस किया तुमको तो किया ना
Yes, tell me, what do you want?
My lord, I have filed online application. It's dated 24/7/2024. It's lying pending with the department since.
So, Mr. Mishra, we will only say that you considered the application in the light of the larger bench judgment and take a decision. Take a decision and communicate.
After fulfilling all the formalities.
Yes.
By the petitioner.
No, we will say in the, needless to observe, in the event his prayer is acceptable,
Lordship.
you will grant connection subject to compliance.
Lordship.
That will not if they upload the status that rejected, you have to again come back to the court. So you ascertain, you serve, you ascertain and move. But I was minded to dispose it off. In Mr. Mishra, what is our appellate side rule says that it has to be served. But do you accept the service and
No, but generally I. But it will create problem. I have to get the instruction. Without instruction, I cannot appear. And we are draft of electricity. That is the.
no, that of electricity is a different issue altogether. Next two matters are yours, same order. Then don't record Mr. Mishra's present because service is not complete.
That's
Not
Number 4.
I'm in position.
Where is your brief? Oh, you don't have the brief.
So that, sir.
These 3 years left.
But online applications.
Nothing has been said.
Lordship, as per my instruction, Lordship, this application has already been filed.
Rejected. It has not been uploaded.
Has been uploaded, but I do not have, right now, I do not have the
Today
copy.
morning I had just, it is, nothing was updated. I don't know whether present it is updated, but in the morning at 7 AM, I checked, nothing was updated. It's not password, not right now, I'm checking, like, the rule was rejected or what the status of it.
No, then the petition becomes infractious. You have to challenge the
Not password.
very good. Pass over.
Item number 5. WPS 1 of 2025.
Lordship, I have
My lord,
taken
in this
this-
matter, I am appearing for the writ petition, my lordship. An application has been made before the electricity department. They had rejected my application on the ground that
No, certificate of income.
no objection certificate has to be taken from the owner of the premises, which is appearing at page number 19, annexure P3.
This has been already decided.
Already decided, my lordship. Page number, the relevant portion is at page number 27. Inner page number 7. Paragraph number 3, my lordship.
Paragraph clause 5.3.
Clause 5.30 of the supplied code in no manner whatsoever fetters the right of an occupant to get electricity connection, even without any no objection certificate being produced from the owner. And final order was to grant the electricity connection to the encroach. Page number 29, inner page 9, my lord. Last second paragraph.
You have not challenged that order.
My lord,
Rejection order you have not challenged.
this is not a rejection, my only intimation, only the intimation has been given.
Application
No,
rejected.
my lord, but specific order,
Page 19.
yes, but no order has been for that reason. It
Yes,
was
remark has been given.
remark, my lord, for that reason only. I pray that then my lord, I may be.
Yes, this remark does not
Yes.
stand, Mr. Mishra.
Lordship,
In view of the judgment,
Lordship, I got the instruction, Lordship.
yes,
Wiring and earthing is not proper.
That,
This is the report I am having and kindly see the condition of the house. He is written that it is a dwelling house, kindly see. Lordship.
Then,
Photograph I have got it.
then you should have mentioned that in the certificate. Rejection, you should have.
Yesterday, because I have instructed them to inspect it and give me instruction. Yesterday they have inspected and they have given me instruction. In the
And my-
petition he is writing.
No, I will only say his application you will consider
Yes.
And it cannot be rejected on this ground because this has been set aside,
Yes.
only on this ground.
Yes.
I will dispose of the application.
And rest of the, because.
Just like that, my lord.
Wiring and earthing is not proper, and kindly see the condition of the house.
That can be done by the writ petitioner, my lordship. He can give an undertaking.
It is pleaded before this honorable court, it is a dwelling house,
Yes.
they are residing over there, kindly see lordship. It is a godown,
My lordship.
everything should be clear, crystal clear before the honorable high court.
Undertaking can be given by the writ petitioner, my lord. Wiring or earthing whatsoever, it should be done.
So that will come within the formalities which have to be complied with by them. Unless the formalities, direction is given subject to.
Before the honorable high court, by way of filing this writ petition, what they have stated, paragraph 4 may kindly be seen lordship.
Para 4.
That here petitioner states that the encroachment done by the petitioner was prior to 2000 and the petitioner had constructed a building dwelling house on the revenue land and using it for its residential purpose. Kindly see the photograph. It is a good.
Photograph I cannot see. Photograph that is for.
File opposition there.
My
Yes, I am not saying that you grant connection.
yes.
I will restrict myself only to the issue of that of that objection.
5.3.
Yes.
5.3. Now, and I will say that now you take follow-up steps.
In the month of March, Justice Kesarwani has also passed an order in WPA number.
That has been subsequently taken up, and Justice Bhaskar Bhattacharya's judgment was governing the
It
field.
is of 2024.
Right, 24, it was placed before another single bench.
Yes.
A single bench deferred with, it is not deferred, it said that the earlier verdict will.
Judgment for the
Yes.
single bench is not binding upon.
That you argue there, the present writ petition.
But if my submission may be recorded as a paragraph 4, I have objected to.
The present writ petition has been preferred, challenging inter alia the. Why having to challenge the order of rejection?
My lord, since it was a remark for that reason.
What you are saying?
lib-
Have you written the date of that rejection anywhere in your paragraph?
Yes, in
Where? Which paragraph?
page number 5, paragraph number 10.
Rejected the application.
Rejected, my lord, but the communication.
Challenging inter alia the denial on the part of the respondents to grant electricity
Lordship, I have also seen.
Forwarded to?
Junior. It is pending with the authority.
Asha.
Time on.
Acha, the present writ petition has been preferred, challenging the inaction on the part of the respondents to grant electricity connection to the petitioner. Mr. Learned advocate appearing for the petitioner submits that the petitioner is in settled possession of government revenue land as detailed in paragraph 3 of the writ petition, bracket A hereinafter referred to as the said land. And he is residing in the same upon construction of a dwelling house. Stop. The petitioner submitted an online application for grant of electricity connection on 20th January 2025, but the same has not been disposed of till date. Mr. Misro, learned advocate, enters appearance on behalf of the respondents and submits where you have given it on. When was the application given? Page 20?
20th January.
2020.
Mr. Misro, learned advocate, enters appearance on behalf of the respondents and prays for leave to file affidavit in opposition. Stop. Upon hearing the learned advocates and considering respective parties and considering the materials on record, I am of the opinion that no useful purpose will be served by keeping the writ petition pending, and the issue needs to be relegated to the competent authority. Accordingly, the writ petition is disposed of, directing the respondents to consider the petitioner's application for grant of electricity connection and to take appropriate steps towards grant of electricity. To consider the petitioner's application dated
20th January.
20th January. Respondents is includes according writ petition is disposed of, directing the respondents, particularly the respondent numbers 3 and 4. You do this in the earlier matter also. To consider the petitioner's application dated such and such, and to take appropriate steps towards grant of electricity connection in favor of the petitioner, subject to compliance of all necessary formalities by the petitioner. Next, the above exercise shall be completed within a period of 4 weeks from the date of communication of this order. Stop. Disposed of.
WPS number 325.
It is same as item number
And item number 5.
It's the report.
On the ground that I have to take no objection from the owner.
Same matter.
Item number 5, but kindly see the house, condition of the house.
The house is there.
Nobody. Kindly see her.
Ration card, I have informed the ration card.
But if anything happens, if anything happens.
So don't give them. In the formalities, he must be having a reasonable dwelling house. If cattle are there, you cannot give. You ask your officer to reject it on that ground. Compliance of necessary formalities means all reasonable formalities.
Sir,
You will give connection today, tomorrow a fire will break down, then what will happen?
that is.
It is your responsibility.
But
Mr. Mishra, try to understand. It is a question authorities, what happened? On this ground, you can reject the application. That according to you is a necessary formality.
but
You can call upon and say, first you make the earthing, then you do this thing. Or you remove this shade and put something else. Safety purposes are never compromised. So why your officers do not do so, I do not understand. Now the window has been opened. Once application made, give it within 1 month, otherwise we will come to court. Repeatedly you have been, what was the initial objection, how the case is projected? Initial objection was that you are an occupier, you don't have any title to the property. So that got rested with the subsequent judgment of the larger bench. Now then there was a confusion, another division bench said something that is in progress. But the thing is that necessary formalities is it does not mean that you automatic court has directed you to grant, irrespective of ascertaining the safety considerations, which you have under JERC. Why this no objection provision was incorporated in the clause? Try to think in some other manner.
here,
If you go on the basis,
here,
Hmm.
the Tahsildar used to read the no objection. To the encroacher.
so ascertain this thing, you are a public authority.
But
I have applied to you that give connection to my house. I am with my family, they cannot, I cannot. So you have a public duty to discharge, but that cannot be at the cost of compliance of appropriate formalities. If you find that it is a safety issue is involved, you can certainly deny them, or you can call from them, you first satisfy the safety consideration, then I will consider.
in 4 weeks time is granted before, after the order of the Honorable High Court officers are under threat. So that is the difficulty. I will call them and I will explain this.
Threat of contempt, yes, that is, but Mr. Mishra, they have to understand the rider
But I will call them. and-
formalities.
But
If you are, if in your, if your assistant engineer says that earthing is not proper, so then you have to give a notice to him that you do the earthing properly and come back to me. There are ways and means out, otherwise it opens a floodgate, you are right. Everybody will come with an application. It is same as 8 করে দেবেন, ওই same as 5.
Item number 5.
Challenge the rejection order.
5 is, where is that rejection order page? Oh, that Mr. Cherian, ye wo marked out. You put it there. Just check it up if it is the same. Yes, disposed of.
So please.
In contempt, you will get that clarification. Even if a contempt is filed,
But
you will get that clarification.
Number 7. WPA 220 of 2025.
yes, 7.
দেখি, কি আছে?
But generally I used to appear, but no copy has been there and nobody is appearing.
হ্যাঁ, হ্যাঁ।
So let it be in the next second, madam. Because, madam is submitting this. Let it be in the next second.
Yeah, just one. No one appears on behalf of the petitioner, though Mr. Mishra. You have instructions
Mr. Calcutta, he is in virtual mode of Calcutta. And very candidly, may I kindly be allowed to file the affidavit of service, this is scanned copy. And may I submit that it is an important omission on my part. Original slide is it, yesterday I showed it, the scanned copy. And
But sir, who is opposing you? Mr. Chakraborty, you are there?
GST, where my usually Mr. Kundalia appears from.
Then sir, you have to wait till the next cycle. You keep that with you. You keep the, sorry, in the meantime, you.
Service has been affected.
Service has already been given affected, my lord. I am advocate and record in this matter, my lord. I have already served.
Your lungs at, because it's served, when, see,
My lord, copies has been served upon the respondent, my lord.
when?
At the time of filing, just after filing, my lord.
When did you file it, sir?
My lord, affidavit of service, my lord, I have already sent Mr. Roy the scanned copy of the affidavit of service. Original is lying with me, my lord. I will send the same in the registry, my lord.
Affidavit you have not filed, na? Affidavit of service.
It is lying with me, my lord. Original is lying with me in Calcutta, my lord. Well,
Ah.
I will send it to the registry, my lord, as early as possible, my lord.
Mr.
Triptimoy Talukdar, my lord.
ওনার নামটা কি?
Dipanjan Roy is appearing before your lordship.
Mr. Roy, learned advocate, assisted by Mr. Talukdar, learned advocate, appears on behalf of the petitioners. However, no one enters appearance on behalf of the respondents, whose presence is required for adjudication of the present matter. In view thereof, list the matter for further consideration before the next available circuit bench on 10th June, subject to the convenience of the Honorable Court. Stop. The petitioner is directed to intimate this order to the respondents and file a fresh affidavit of service.
Yes,
I'll do it. I'll do it. Get it.
Item number 9. WPA 196 of 2025.
My lord, I am appealing for that decision.
আমি দর্শক দিয়ে দেখে না আমি একটু উঠে তোমার অর্ডার দিয়ে সই করে দিই 8 ঘন্টা পরে বসলাম তাহলে ওগুলো অ্যাটলিস্ট আপলোড হয়ে যাবে
My lord, I am praying for a direction.
Yes, Mr.
Yes, I am praying for a direction for removal of the electric meter installed by the private respondent in my premises. Here, my lord, kindly come to the
Is your service complete?
service completes, both the parties are and official letter, Mr. Misra is appearing.
I am appearing for respondent number 1, 2, and 3.
This is the dilatory tactics. This is the tactics fourth I have served. Today is 11. I am having the document to show that it has been served on 4th.
Now, what prayer you are making for removal?
Removal of the electric meter which was installed by the private respondent in my land, in my council, misinterpreting the order passed by this honorable court. This honorable court directed to the authority to install the electric meter in the name of the private respondent in which he is in settled possession. He forcibly entered into my land and in which the civil suit is pending. Tahsildar recognized my possession over that land by issuing a so-called notice.
Then you are not enjoying electricity.
No, it is a council. It is there is no electric wiring. There is
All right, we shall call for affidavit and we will make it clear. We will make it clear
Yes.
that the installation will not create any right, title or interest in our favor.
Yes.
We will say that.
Another thing,
And let them
file the opposition, no problem.
So far as disconnection is considered,
Yes.
we will consider that on
Yes, my lord, no problem. But till that period, till that period, they will recognize that land, their occupation.
How?
Yes,
It is
already, no,
yes.
no, I am reading the document, how it is your occupation.
Where is your Miss Nal? Wait, we will hear you.
She can say this in her affidavit of opposition, no problem. But once
Let us see what story you have made.
Yes,
Let us see.
yes. My lord, first of all, my lord, kindly come to page number 18 of my writ petition. It is a patta pass.
You are strong opponents to each other. If you had been on hard side, you would have also said this. Yes, Snake.
Page 18, 1
Mr. Mistro is lost in the battle, or you have something.
No, lordship. Mr. Misro in the first occasion objected to grant of electric connection.
Yes. What he will do is a creature of statute.
He stated.
I stated that petitioner is on the occupation of that.
Yes.
Tell us what you are showing.
Yes. Page number 18 is the patta passbook of a record land which has been allotted in the name of my father, Adhir Mondal. The page number 18 is the title page.
Achha, yes.
And page number 19 is the record. Here name Adhir Mondal. He died, who was my father. Land bearing survey number 315, 316 by 1, 316 by 2. This is the recorded land allotted by the administration. This landed property in the year 2018, my father sold to the private respondent.
This page 18 property.
Page 18 is the title page, page 19 property.
Page 19.
Page
Yes.
19.
That is at survey number 315, 316 by 1 and 316 by 2. You sold it to the private respondent.
My father sold it to the private respondent.
That is
in the name of my father.
very good. That is to Deep Singh.
Deep Singh.
Very good. Then what happened? That was done in 2018.
2018. As because it is allotted property, administrator allotted for entire family, I filed a suit. Suit is pending for cancellation of sale deed. Suit is pending. That is not the subject matter of this writ petition.
Cancellation of the deed. Sale deed.
Sale deed. That is pending, which is not the subject matter of this writ petition. Now, this landed property is surrounded by revenue land, government revenue land. In the year 1985, I have enclosed that government revenue land. It is under my occupation, out of which one survey number is 289.
285.
289.
All right.
Now, it is surrounded by some other 317 and some other land. 289 is the subject matter. Now, my lord, kindly come to page number 21, the show cause notice. '87, I have enclosed. I have constructed my residential house. 2019, I have started construction of my cow shed because I am engaged in dairy farming business. I am having the Jersey cows. So to keep the cows, I have started construction of my cow shed. So the Tahsildar once started new construction, Tahsildar Portdar issued a show cause notice, which is the recognition that I am in occupation of this landed property. My lord, I am reading the first two paragraphs. Whereas report has been received from the revenue field staff by Purno Chandra Mondal, who is the petitioner hearing. Son of Adhir Mondal, R.O. Ramnagar, Neel Island, is constructing a house on the government revenue land covering an area 50 square meter out of survey number 289, situated at Ramnagar village in Neel Island. And whereas the report of the revenue field staff reveals that land bearing survey number 289, area 0.455 hectare, classified as C3, situated at Ramnagar village, Neel Island, recorded as government revenue land. So this is the recognition that I am in occupation of that particular landed property. Now, thereafter in the year, this is in the year 2018, notice dated 19 January 2018. Then thereafter 18 July 2018, order has been passed by the Tahsildar, eviction order, to remove me, to evict me from that land, particular landed property. Challenging the said order,
I filed a suit for declaration of title, which is pending before the Court of Learned Joint Civil Justice, which is still pending. The Revenue Department is contesting this suit, still pending. Now, my lord knows that in view of section 202 subsection 8 regulation 66, there is an automatic stay. So nobody, this private respondent doesn't have any access to enter into his purchased land, which was sold by my father to him.
Does not have any.
Access, because this purchased land, which was sold by my father, that land was surrounded by this government revenue land. So he tried to occupy this landed property, survey number 289, which is in my occupation since the year 1987.
So then who is in occupation on by virtue of the sale deed? By
That
virtue
particular land is in his occupation. No,
in his occupation.
his occupation. But he required this landed property, government revenue land.
Then
to have the
what,
access.
then what happened? In the suit under 202, you have obtained an injunction or no?
That is pending. No.
That is pending.
That is pending. The private respondent is not party. It is between me and the revenue department.
Yes,
Revenue
then what happened?
Then what happened? This 2023 first time, the private respondent tried to enter and occupy that particular landed property and my council. 2023.
That is of 289.
289.
289 was sought to be encroached.
Yes. Then on 12 January 2020, which is at page number 50, on behalf of my client, I made a complaint to the superintending engineer.
Page number 50.
50. Because in between that, I have enclosed the plain and written statement of that particular suit. So I made a complaint to the superintending engineer because this private respondent is a very big businessman of this island. Now, using his man and money power, he is tried to encroach this particular landed property and my council. So I made a complaint, page number 50, to the superintending engineer and the superintendent of police, because managing the subordinate staff of the electricity department of Shahid Island and the police station Shahid, he tried to enter into that landed property in the year 2023 itself. So I made a complaint. And complaint, I have enclosed the copy of the complaint. Then again the electricity department tried to, the junior engineer tried to give electric connection on my cow shed. Then again on 22nd November 2023, I made another complaint to the superintending engineer, Department of Electricity. Because of the interference, because of the objection, the private respondent did not get the electric connection there. Now,
he applied for electricity connection.
Tried to get, not applied on that particular.
There was already a electricity connection was there, his meter was missing, he has applied before the authority. All these things has to come by way of filing.
Now what happens? No.
He is making
Let me finish now. He wants to say.
Let me complete. Then this private respondent filed a writ petition before this honorable court, WPF 420/2024, in which I was not the party. Then in that case, the land, particular land is under my occupation. I have not been made a party. Here the electricity department raised objection.
Yes.
Here, my lord, kindly come to page number 54, the first order.
We have seen it.
Here, yes. It is submitted by the respondent that the possession as claimed by the writ petitioner to the land in question where electricity connection sought for is in dispute. The respondent therefore prefer filing an affidavit to disclose their stand. So I do not know whether I was not party, whether they filed the affidavit of position or not. I do not know. Then how this private respondent managed the electricity department and referred the matter to the Lok Adalat. And Lok Adalat, page number 55, passed an award. The dispute between the parties has been listed for determination by the Lok Adalat, and the parties having compromised settled the case. The respondent number 1 herein, the private respondent managed the respondent number 1. She was personally present. She has given consent to give electric connection. And this award has been passed. Now kindly see what type of award has been passed. I am showing the document. Last paragraph, parties agreed that supply of meters shall not be construed as declaration of the court on the right, title and interest of the petitioner in respect of premising of sale. The petitioner will accordingly comply with necessary formality and the electricity shall be supplied through a new meter within a month from compliance of formality. Petitioner will approach the electricity department on the basis of order. After this, the assistant engineer issued a notice, which is at page number 57. This is very vital. In compliance with the judgment date passed, Honorable Lok Adalat at Calcutta, 13th WPS Satansa, in the matter of Sri Rupdeep Singh versus Superintendent Engineer, requiring you to comply with necessary formal owing to supply of a new electric meter by this department. Therefore, you are hereby requested affix the meter board in your premises for fixing of energy meter by the department on 2/4/2025 at 10 hours to be present to establish the physical and settled possession to facilitate the process. Now, what the private respondent did, this particular landed property is not under his occupation. On third, he came along with a person, police department and electricity department forcibly entered into the land and affixed the electric meter without wiring, without earthing, nothing is there, electric meter on my cowshed. Forcibly entered and affixed the electric meter on my cowshed. So there is a notice, the private respondent has to prove his settled possession over the land. He was not in possession. Occupied the land.
Why didn't you intimate that to the police? 20th March was the act, he was asked to be present on 2nd April.
Yes.
If such a big incident has occurred, you will not file a complaint before the police.
Police came, police restrained me. The police restrained me. I am having the photograph to show how the police restrained me.
No, photographs all right.
The police came there. Police.
Now what do you want?
Removal of that electric meter. Let this electric meter be affixed in his settled possession in his recorded land, no problem. Why is the electric meter in my occupied land, in my cowshed? Now my Jersey cows are outside of the cowshed. That cowshed was occupied by the private respondent already.
Now what is the state now?
He occupied the my.
It's always in my occupation.
My domestic animals are outside. Always how it has been settled. There is a document to show that it is my occupation. The Tahsildar issued a notice, so-called notice, order has been passed. Let them show any document that it is in their occupation. Even the electricity department knows very well that it is not in their occupation. That is the reason electricity says that we are under.
What interim order you are wanting, Mr. Haldar?
Let there be a status. Let there
Status
be a
quo will
status.
help the other side. If we pass status quo, it will help her. Because there is a serious dispute as regards this.
Yes.
So if you invite me and say that you.
My main prayer to removal of the electric meter. Removal of the electric meter. My main prayer is removal of electric meter.
No, that we understand.
My lord.
Your argument.
My lord correctly held that if my lord passed an order that this electric meter, installation of this electric on my land shall not create any right title interest of the private respondent, then it will survive.
It's
It
already
is already there.
No, the order is there. It's already there.
Lok Adalat, on the basis of the order passed by the
It is not local Adalat.
this thing has been subsequently happened. By the notice. No.
To enter upon my land.
No.
That is the.
Now the private is trying to recognize his possession over my landed land.
He has not paid.
Mr. Haldar, good, bad, indifferent problem has started.
Yes.
Now, it's a question of possession is a very slippery issue.
Yes.
Anybody can come and say, I am in possession, give me status quo.
Yes.
Though I am
But
not
I
in
am
possession.
having certain documents to
Even if
my
we-
possession, prima facie possession. But the private estate doesn't have any.
But the privacy possession, if we, how will we protect? It is now you are saying it is in their possession, though you are
No,
the
it is
person.
not their possession.
Then why you are wanting? You are wanting removal
From my cowshed.
Hmm.
From my cowshed. That is my only prayer. Land is not under their
There is
occupation.
no intervening prayer. I am praying that direction will be given to the to file affidavit in opposition. I will prove that I have documents to show that he has given
Nothing.
my permission since the
Nothing
since
is-
beginning.
Even in the first petition filed by the private respondent, he failed to produce any document that the land is under his occupation.
The notice
He
which
failed.
he is producing.
That is the reason the electricity filed opposition that that particular landed property is not under the occupation of the private
It has
respondent.
been in my position since the beginning. And the meter was missing.
He
and
purchased the land in the year 2018. He's a resident of Port Blair. He went to Shahid, purchased the land 2018. He's in occupation since 1987.
Who said 1987?
Affidavit of no, Mr.
The parties are appearing.
Mr. Haldar, learned advocate.
is not appearing. Respond number
For private, for
Mr. Chakraborty, you appear. SHO, you appear. He will appear, no?
Yes, sir. Police department.
Have you served upon police department?
Yes.
You have raised your affidavit of that. Recorded name.
Is not updated in the internet, but what information from Shahid that he received. The SHO received.
আচ্ছা এরকম লেখো মিস্টার হালদার লার্নেড অ্যাডভোকেট অ্যাপিয়ারিং ফর দি পিটিশনার submits that the private respondent number 5 in collusion with the electricity authorities and the respondent number 4 has illegally obtained an electric connection upon affixation of a meter on the land in respect of which the petitioner herein is in settled possession. By virtue of such electric connection, the private respondent is attempting to secure a right over the said land, of which he is neither an occupier, nor a tenant, of which he is not an occupier, Stop. In support of such contention, he has drawn the attention of this court to several documents annexed to the writ petition. Ms. Nag, learned senior advocate appearing for the private respondent, vehemently opposes the Mrs. Nager aage arekta daও। Stop. He further submits that necessary direction may be issued to the electricity authorities to immediately remove the electric meter which has been installed in the name of the petitioner on the land bearing survey number 289. Stop. Ms. Nag, learned advocate, senior advocate, appearing for the respondent number 5, vehemently opposes the petitioner's prayer and submit that the said respondent had all along been in possession of the said land in survey number 289. The disputed questions which have been urged, the questions which have been urged by the petitioner in the present writ petition না the আগের লাইন থেকে লিখলে 289 বললে, হ্যাঁ, the writ petition the dispute involves disputed questions of facts, and in fact the writ petition itself is not maintainable. Stop. Mr. Misro, learned advocate, appearing for the respondent numbers
1, 2, and 3.
1, 2, and 3. And as no one appears today on behalf of the respondent number 4, this court directs Mr. Chakraborty, learned senior advocate, who usually appears on behalf of the administration, to appear in the present matter on behalf of the respondent number 4. Let such engagement of Mr. Chakraborty with a junior of his choice be regularized. Stop. There exists an antagonistic controversy among the parties to the present writ petition, and as such, in my opinion, the same can be heard only after inviting affidavits. However, it is made clear that the installation of the meter in the concerned land would not create any right, title, or interest over the said land in favor of any of the parties. In favor of the
Private respondent.
It is, however, made clear antagonistic needs to be heard upon exchange of affidavits বলেছে, তারপরে লাইনটা however it is made clear that the installation of the electric meter in the name of the respondent number 5 shall not create any right, title, or interest in his favor over the said land. Stop. The respondents are directed to exchange, their respondents are directed to file their affidavits in opposition within 2 weeks from date. Reply thereto, if any, be filed within 2 weeks thereafter. List the matter for further
Let
consideration.
a copy be given to me, my lord.
Petitioner also should not take advantage of their order in caution. He will try to take advantage of that High Court has said that he doesn't have any right to the interest, he will occupy the. He will go out.
I am in possession. I may be allowed to keep my kettle.
You are apprehending Mrs. Nag.
Copy may be given to me, my lord.
I will
Which is
serve.
later.
I will serve it.
Do I,
The repetition I will serve. Not necessary to record it, I will serve. I will serve. My lord, my kettles are outside of my cowshed. I will be allowed to keep my kettle in the cowshed.
how can I say that, Mr. Hamdan? How can I say that?
Even though there is no
In
order.
circumstances, your lordship, it's a government land. As per him, it's a government stock.
Yes,
order in his
certainly.
name. So how the court can create a right in his favor?
No, that direction will create further complication. Already there is multifarious proceedings. Yes, next one.
Item number 10, WPA 209 of.
And for the private.
Petition, let it be next time. Then, as per this instruction, let it be next time.
What is the matter?
Your worship, there is a settlement going on between the parties.
Can I record that?
No,
Let it be next circuit in meanwhile. It will
next circuit, you should possibly.
দেখি দাও একটু দাও today an adjournment has been prayed for on behalf of the you have served the other respondents.
I'm not reading for one of the private.
You are for the private. Urmila Adhikari. Have you served upon the administration? Who is appearing? Yes, no one, today an adjournment has been prayed for on behalf of the petitioners. Though Miss Nagl, and senior advocate appearing for the respondent number 5 is present. Respondent number 3 is present. In view thereof, comma, list the matter for further consideration, list the matter for further consideration before the next available circuit bench. Before the next available circuit bench. Well, you have served, the administration you have served. Where is your,
Eighth April.
Evident to হয় come with an affidavit of service on the next day. চলো একটু দেখে
11, WPA 215 of 2025.
Lord, I am for the petitioner, my lord. Lord, the petitioner, he is the recorded tenant, my lord. He has purchased the land on the dint of a sale deed. Thereafter, my lord, uh, he has made an online application for registering of the deed. He wanted to sell some portion of the land and some portion of the land through gift deed. He has submitted through online this gift deed and the sale deed. Everything was done. 3 deeds total. 1 sale deed, 2 gift deed. Altogether 3 deeds for the separate portion of land. Now the sub-register has returned the sale deed as well as everything after purchase of the stamp duty, after paying these registration fees also. They have returned it by saying that there is a contravention of provision 159(2)(2) of the regulation. 2(2) of the regulation. That is. My lord, thereafter we have given the representation that has not taken care. I am challenging this return of the deeds, my lord. That cannot be done because, my lord, it's at page 104. 104, my lord. My lord, to the petitioner, subject return of sale deed and gift deeds due to contravention of clause 159(2) subclause 2. This is with reference to the following documents submitted by you through online portal NGDRS for registration at the office of the sub-register South Andaman. Sale deed, gift deed, gift deed. The above deeds pertain to land bearing survey number 108 situated at Bimlitan village, Sri Vijaypuram Tehsil, district of South Andaman, with a total area of 0.5445 hectares classified as hilly. Upon verification, it is noted that you intend to transfer 0.2440 hectares through the said deeds while retaining 0.3005 hectares of land. As per clause 159(2) subclause 2, no occupancy tenant shall have the right to transfer his interest in any land if after such transfer, the total extent of the land held by him will be reduced below 2 hectares. Since the remaining land after the proposal transfer would be, it will be less than 2 hectares. Here, my lord, 159(2)(2). May I read once, my lord? On my lord, my total land is 0.5445. It's below 2 hectares only. I have purchased it, it's below 2 hectares. I purchased the land below 2 hectares. In that land, some portion of the land I want to sell it and gift it. That I have submitted before the sub-register for registration. Now they are saying, well, that's why I want to read fully. Less than 2. I don't have 2 hectares. Then this will not apply to me. That is my contention, my lord. That I will read once, my lord. 159(2)(2).
In the past. My lord, I don't have that order right now, my lord. We can file our affidavit in that similar order as
Similar order.
It will help the petitioner, I'm saying.
Mr. Binu Kumar was there.
No, but that
We got the order. And my lord. My lord, no. My lord, no, my lord. No, my lord. My lord, here Article 14 also comes, my lord, because my lord, 2 deeds. Prior to this, 2 deeds, they have registered it. My lord, 2 deeds, they have registered it. Kindly say this is below 2 hectares. They have registered it. That is also there. My lord, kindly come to now. Regulation 159, my lord. It's at page 30, my lord. Regulation first part, page 30, 159, my lord. Lord, 159 2 subclause 2. May I read one?
Yes.
2 subclause 2. No occupancy tenant shall have the right to transfer his interest in any land if after such transfer, the total extent of the land held by him will be reduced. If after such transfer, here my lord, before transferring, the land is below 2 hectares. Not applicable, my lord. This is only with regard to if I have more than 2 hectares of land, then this will come, my lord.
As far as I recall, my lord, it was decided in favor of the petitioners there.
My
But
lord.
my lord, that order has to be seen, my lord. Detailed arguments were advanced, my lord. Matter of validity, violation. Yes.
No, if that has been adjudicated on, why should we take the trouble?
Then that order is not.
Is it, do you have that order?
Come on. Next circuit, my lord, they can place it.
My lord, till next circuit, my all the notice and compliance validity will expire, my lord. Sudha. K Sudha karke. My lord, let it be passed. Let it be passed over, I'll place, my lord. K Sudha, name is K Sudha here, my lord. Because, no, my lord, why it's required, my lord?
Final arguments.
Mr.
Legal-
Chakravarti, this is the only point.
Only point, my
If
lord.
it has been adjudicated, we will dispose it of.
My lord.
Was it implemented? Yes. It was implemented.
It was implemented by
It was
the,
registered.
then in
Then
that
why
case,
is- But then this, why is the authority then insisting on it unless there is some appeal or some kind of?
And these two registration was done, my lord. These two
নাম্বারটা
registration
দিলে
is-
পাবে না, বের করতে পারবে। আরে ম্যাডাম, we are not concerned with that. What is the name?
K Sudha.
দেখো না। So your validity is expiring when?
My lord, it's one.
So it is not that your stamp paper will become invalid. It is of
But-
March 2025.
My lord, stamp paper is there. Even I've.
We shall,
paid the
but
fees.
he should also get an opportunity to take instruction, no? Let us see if we get it.
My lord.
It's very surprising that despite that order, the authority has passed this.
Maybe the authority was not apprised of that. It may be so.
For some other persons, they have also done it. That copy is also there with
But
me.
on that basis, if
Same,
there
it
is
is the same quantum of land is, it was less than 2 hectares. It was less than 2
all
hectares.
right, madam, let us see if we get it.
My lord, let it be passed over, my lord, then other matter can be taken. In the meantime, it can be taken up. पचास आपको दे दूंगा मनोज भाई 50 आपको मैं दे दूंगा It's just percent.
WPA 685 or 20. 685 or 20. Whatever. No, it's.
No, madam, this is not that, there the person was having property at 3 different locations.
But the land
Because the purpose, court said, purpose of 159 was to prevent fragmentation or reduction to a particular extent. Purpose, object of the statute is to prevent fragmentation. Now it is your case that on the same place, you are having an aggregate of less than 2 hectares.
here also.
Please try to answer. Now this less than 2 hectare, they are not allowing. Object is we will not allow fragmentation of a property which is less than 2 years. If the remaining what remains is less than 2 years, then the fragmentation to that extent is not allowed. But this judgment was delivered upon referring to another judgment passed in a civil order of 1996. So, madam, this has to be gone into. This is not pat on the issue. Subject to what you say.
My
Yes.
lord.
So, but Mr. Chakraborty, I am not asking you to file affidavit. You go through this judgment as well as the CO and come back and tell. Otherwise, file affidavit will never be heard. Oh, see, hearing matters, you people are not doing. See how many hearing matters. Hmm? All right, I am referring to it. You come with that issue. Miss Jimmy Lanet, advocate appearing for the petitioner submits.
WPA 216 of 2025.
My lord, I am appearing for the petitioner. The matter has come for the first time, my lord. I have served yesterday only to the respondent authorities and today the counsel for the electricity department. The service affidavit in service is not ready, my lord, but I have served the receivings I have at hand. My lord, this is a matter where electricity was denied to your petitioner, your lordship.
Minister has requested me to take not today in this matter. He went to some personal difficulty. Went out. He received also, he has told me that he received today morning one day. He does not have instruction.
Why it is not?
Rejected, my lord, because they are saying that I don't have proper proof of occupancy, the possession. I have given ration card, my lord. I have given the order of rejection, my lord, comes at page number 26. My lord.
Their master of the letter was earlier delegated.
Yes, my lord, because the application was pending for more than 6 months and they were not deciding upon it, my lord. So the honorable court. The last part, my lord. My lord, may just see the last part, my lord, page number 27, my lord, which says that however, the applicant have the liberty to submit a fresh application for a new electricity connection in respect of the encroached land, subject to compliance with all the conditions and requirements as mandated under clause 5.30 of the JERC regulation 2018.
But they can do that. Then morning is when Mr. would be able to.
My lord, the proof of possession, my lord, I have placed before them along with certain declarations on affidavit. On that ground, my lord. No specific reasons, my lord, only that I have not complied with 5.03 of that JERC regulation, my lord, which has been struck down. And in terms of the 26. My lord, I don't have it at hand, my lord, the exact clause of the regulation. My lord, at the second para of the order, my lord, of the impugned order, my lord, and whereas as per the extent legal provisions and prescribed procedural framework, all new applications for the grant of domestic electricity meter connections involving encroachments on government land by the applicants are processed in strict compliance with the directives issued by Wide Andaman and Nicobar Administration Circular Number JRC. My lord, they have also placed the court order of the court, my lord, which has no connection, my lord, with the incident, because in this order which they have relied upon while passing this impugned order, the petitioner was not present, my lord, and it was solely on the ground that the petitioner was not present. In the absence, the order was passed, and the petitioner could not show the proof of possession. Yes, my lord, I have that judgment, my lord. Similar order.
Representation. He is saying pending. He has given chance to apply again.
Milord, if Milord, they will give the same reasons and they'll reject again because Milord, they are, despite submitting the proof of my possession, they are denying my proof of possession. Milord, 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 the last day of circuit.
compassionate appointment. There is a clear-cut requirement under clause 13 of the said memorandum, my lord, which is a compendium of all the memorandum, my lord. So, my lord, this is pending. Let them file an affidavit to this regard, because from 2014 I am working under them. They have taken application.
What is the compilation there? What is that clause?
Clause 13, my lord.
What does it say?
My lord, I have reproduced it. I have enclosed the compendium also, my lord. My lord, may kindly, if my lord sees from page 8, I have reproduced it. I have enclosed it also. Page 8, my lord, will find relevant clauses which are necessary. I have incorporated, my lord, in para 16. There I have taken this exemption and all with regard to para 13 is relevant procedure, my lord. It says some departments such as CBIC, DO Post, Defense have devised their own point-based merit system for processing claims for compassionate appointment. No, I have been given contract appointment for a meager salary. My lord, the law says, my lord. My lord, compassionate inception.
This clause will apply at inception. What is the exempted category schedule?
My lord.
like our West Bengal Regulation Act, there is an exempted category.
Yes.
In respect of those vacancies, compassionate appointments can be called.
Yes.
Now, what they have done is, though they have on compassion basis given you, they have engaged in contractual.
Contractually for a meager salary.
That you cannot do.
That they cannot do, my lord. That
They cannot do, we understand, but that is you now, you have accepted that.
no, no, my lord, with mighty state, I am a widow having two minor children. But what is the option? No, my lord, what I am on, my lord, they are under consideration because they have.
They will not keep any post, they regular vacancies, they will be filling up from exempted category. They will, this.
My lord, that's-
This is all through central government procedure.
This is a scheme which says 5% of the post ought to be filled by.
5% fill किया है कि नहीं?
Yes.
जब भी खाली होता है तो board बैठ के consider करते हैं, जब भी खाली होता है. But why will you go through this process?
Actually not required, my lord, because the compassionate scheme says no a person should be appointed on contract or daily wages. There ought to be an appointed on regular basis. And the scheme itself says, no, my lord, it's rightly pointed out.
My instructions are that 5% because there is no vacancy, that is why they could not be accommodated and were given contractual benefit.
From last.
It was for their advantage that it was given contractual, otherwise they wouldn't get.
Filling up exempted category, that means you have sanctioned vacancy.
No, those vacancies are, my oral instructions are, those vacancies are filled up by such compassionate appointments. only.
It was never.
And some is pending consideration also.
It was never.
Affidavit, my lord, otherwise, my lord, it can be sent back.
Affidavit, man.
Otherwise, it can be sent to the authority.
No,
for
my
consideration.
lord. Let an affidavit be
We'll
filed.
file a-
But this is pre-nature.
No, yes, authorities will reject. And these poor persons once again have to come to the court of law.
Determined by months.
Yes, once for all, my lord.
I am told, I have been instructed Mr. Dwivedi that it is pending consideration under the board. It was, they had not been rejected. Even their cases are under consideration, my lord. That is what he's saying.
Very good. All for every.
Yes.
Meantime, it is considered. for-
I am grateful.
Yes, ma'am.
There are 13, 14 people.
There are 13, 14 people.
Item number 14.
And for the petitioner, here, your lordship, the petitioner, he has applied for registration under clinical establishment
Page
act.
number.
Provisional registration was granted to him. It was granted in 2021 for a period of 1 year. In 2022 also, it was granted for a period of 1 year. Thereafter, when he submitted the application on 13th October 2022, the authority has given a reply asking him to submit no objection from the pollution control committee. Now, when he is going to the pollution control committee for obtaining the no objection certificate, the authority is saying that you have to bring a document showing that the land is diverted into cover. Now, when he is applying for that, he's already applied for conversion. Application is pending. The authorities are saying that they have instructions from the central government not to divert any land at present.
Miss Naz,
Similar
similar matter I have disposed of, Mr. Chakraborty.
This is in the same.
Yes, my lord,
There
same
will be some changes in the facts.
WP 189 of 20.
I got the order. But some facts, there will be some change in the time.
Another copy. Yes. Then we can go together and make the corrections.
Your Lordship.
এটা একটা জেরক্স করে দাও না এটা তো এটা একটু একটা কপি বের করে তাহলে তো না can you indicate what are the changes?
I think in that case, Your Lordship, it was the application for first time.
Yes, and under
Your Lordship, already twice provisional registration has been given to you.
acha you place the facts.
Yes, Your Lordship. Your Lordship may kindly come to.
Have you annexed that board of directors meeting?
That I don't have, Your Lordship. I don't possess that meeting. And there is possibly that actually I tried to find out, there is a, I think, mistake in the order.
What?
Date mistake is there, I think.
Which date?
The minutes of meeting date. December 2025 is written.
No, it is 23.
Your Lordship, I think the one which I have. Which is December 2025 लिखा है मुझे समझ में नहीं आ रहा था which one is that.
Yes,
Which जगह
Yes, it should be 23. 27 December 2020.
So I could not get that one. But Your Lordship, in May 2024 also the minutes is there. I have the minutes of meeting of 7th May 2024. There also they have taken that decision. Kindly see action and discussion.
Correction করে দিয়ে যায় Mr. Chakravarti. Mr. Chakravarti, this one I am placing in a supplementary list just now so that I can make that correction. Who is the petitioner?
Mr. Binu Kumar.
Oh, he has left.
No.
ওটা একটা লিস্টে করে দাও ওই টাইপের মিস্টেকটা করে দিয়ে নয়তো আবার আমার কাছে প্লেসড হবে দেরি হয়ে যাবে Yes, you tell us the facts. What
and one thing, Your Lordship, that minutes of meeting of 2023 was repeated in 7th May.
I shall include that.
Now, Your Lordship.
Other portions you have seen.
Yes, other portions, Your Lordship. That is the only some difference I just wanted to place it. एक कॉपी और मिलेगा
ये लीजिए सॉफ्ट कॉपी से
No, we can.
को बुला लो
difference is that in which twice I have been given the provisional registration. Page number 22 and page number 23.
Then what happened?
Then, Your Lordship, I applied, which is at page number 31. This is the application. The date, the online application, Your Lordship, it's very, the printout.
31. Yes. Acha, what is the date?
13th October 2023.
Mr. Kumar,
The next day.
Mr. Kumar, in your matter, Ms. Nag has rightly pointed out, there has been a typographical error. Do I correct it or I leave it?
My lord will correct it, my lord. Otherwise, they take this as a shelter to negate my claim. Then Mr. Chakravarti is there.
No matter, let it be corrected in that case. There is some doubt. Mr. Kumar knows the administration much better than me, my lord.
Is it so?
Yes, of course, my lord. I'm only interacting for 3-4 years, my lord. He's interacted for.
Achha, this anyway, you applied for permanent registration.
Same.
Provisional
Yes,
registration.
same procedure. They have not.
Then now what did they say? It's 34.
30, 34,
Is that they called for certain documents?
Yes, the number one is NOC from ANPCC for biomedical waste management.
Yes.
This is the number one. Now,
Mhm.
Your Lordship, I have kindly come to page number 37.
Yes.
They rejected it.
37.
37.
Hence,
Commercial land document.
since it was not having commercial land,
Document that is not converted into commercial.
commercial land diversion certificate.
Yes.
Acha. Then what happened?
That's it, Your Lordship. They rejected it. So how can I? My application.
Oh, acha. Now, did you make any representation?
Your Lordship, it is there, page number 35. To obtain the NOC from the Pollution Control Committee. Page number 30.
Pursuant to this order.
No. Then Your Lordship, this is not what the representation
No.
can be there.
But what will be relegated then?
Your Lordship, that application, online application.
Where is that?
Online application is 30, page 31.
That has been rejected by.
It's not been rejected. To that, Your Lordship, the page number 34 is the answer. That you produce NOC from this thing. This has not been rejected. That is pending. And similar to the case of Mr. Vinu Kumar, page number 30, Your Lordship, may kindly see. This is the report from Town and Country Planning. That this particular property comes within mixed residential land use. So, therefore, the construction of hospital building is permissible in the mixed residential land zone. Page number 30.
स्टीफन जी उनको एक कॉपी दे दीजिएगा और कॉपी एक निकला दिस वन कैन so that they can share and find out.
इसमें है. I can show it from there.
Mr. Chakraborty's copy only. Let Mr. Chakraborty handle that. এটাকে একটু এটা টু বি মেনশনড আজকে লিস্টে করে দেবো। ও আচ্ছা ঠিক আছে। Yes, Mr. Kumar is there. We shall do it.
No.
The এসে গেছে লিস্টটা?
Lordship, one matter, your lordship, I am suffering, your lordship, because of that. That arbitration matter, your lordship, remember? Your lordship has asked
Yes,
us
yes.
to request the arbitrator, even after that he is continuing, your lordship. What can be done? Your lordship, may kindly see this order. May you accept the reading. Kindly see this order, your lordship. And when yesterday we requested, both of us requested.
Hmm.
He said he will be passing the order, but till today no order is passed. I don't know what would be the position. Even after the high courts, we have mentioned about the high courts, he said that you have not obtained any stay, so I will be proceeding with it.
So very good. He has given you time to file the reply.
I will, how can your lordship,
Respondent has spread to extend the time for filing the statement of defense.
how can I find the statement of defense when I am challenging his appointment itself?
So it will go if the writ petition succeeds. If he proceeds. Now it cannot be done. Today, how can it has to, your mandate has to be cancelled then.
Cancel next circuit, a main hearing can be done. But till such time, your lordship, the proceeding will be stayed. Otherwise, your lordship, we both will suffer ultimately. I am not going to make the.
When is the next
the
meeting?
payment be wasted. They have to make, they already made one payment, they will be paying another amount also. And ultimately, your lordship, the decision of the Honorable Supreme Court is apt to the point. Unilateral.
But we have to consider, madam, how can I take it up today?
Sir, your lordship, I am praying that in 3 months stay may be granted.
No, I can say this, that further time has been taken by the both the parties. So that the to act in terms of the order passed by the earlier coordinate bench. Accordingly, we are keeping it on that date.
My lord, if my comments to your lordship may record that it has been informed that we have taken steps in terms of the earlier order communicated to the learned arbitrator. My lord may record that and keep the matter for.
Yes, the file to the.
Actually, that has happened.
That is happened, we have already informed.
That means, my lord, that will at least give a seal that what we have done is in accordance with what fell on the court. To that extent, my lord. That's already.
So records reveal that by an order dated 24th March 2025,
Supplementary cause list for correction act number WCA 189 of 2025.
My lord, that correction, that 27 December 2025. I think the date would be, I have just seen the file, 29th of December 2022, my lord. Maybe 29th. Page 44, my lord. 43 or 44. My lord. That minutes of the meeting, my lord.
27 December
Yes.
2022.
My lord, my lord. No, it's okay, my lord. No, my lord. My lord has seen it, that's fine. Minutes 27.
Yes, yes. Item number 70, WPA 223 of 2025. Yes.
My lord, by invoking the regulation 161, the complaint has been made against my client. 161 of the Andaman Nicobar Islands. Yeah, but only see, only one point, only one point. The kind of
But Mr. Kumar, no, I will hear 2 points. But the thing is, without service, how can I pass an order against him?
I got the copy. Order copy I got on 10th of April.
Why you are always late?
Eviction order is there.
Yesterday also you did not get an order on this ground.
Eviction order is there. What is the eviction order? So kindly come to my lord. The orders by the Tehsildar at page number 34.
34.
34. The last paragraph, my lord.
Oh.
Keeping in view of the findings and the conclusions to arrive, this court is of the opinion that since the period of dispossession is more than 2 years, the Tehsildar court cannot pass any order in accordance with the provisions of the section regulation 161 of LR.
Oh.
Again, the private respondent prepared appeal before the appellate authority sub-division officer at page number, my lord, page number 30. Page number
30.
30.
That is previous to that.
My lord, 30.
No, you showed us page 34 just now.
No, page 30, no? No?
30.
30. 30. In the appeal.
Against that order?
That order.
Yes, yes.
Can you see arising out of policy number dated 4/10/24?
Very good.
But I am not party to this appeal. But order has been passed. Can you see? I am not a party.
But you are in the matter of Gyan Prakash Mishra versus.
It's not like that, definite.
No, page 34. This RC case was in respect of Gyan Prakash and Horen Badwi and others.
Yes, others includes my client.
How will I know?
Yes, it is their order is submitted there. Can you go to the page number?
34.
Yes, 34. 34. Kindly see the next order, my lord, the same page. Second paragraph. And whereas, second paragraph. And whereas based on the field report, the authorized occupation of Karupaiya is my claim. Karupaiya. For the said and recorded land claim number also in temporary state and fencing area 40 square meter for total area.
So
Is my claim.
against you eviction order was not passed because it was dispossession was more than 2 years. And Tejitral said, I have no determination.
Yes.
Now appeal
That has been preferred, that is the order. I am not a party. But the sub-divisional officer passed an order. Setting aside this order of the Sildar. And for execution of the order, can we see execution of the order data? That is page number 23. Page number 23. By this appeal, we directed the Sildar to execute this order. At page number 23. Very strange. And now, the Tahsildar has issued a notice to me at page number 42 on 15/4 to be vacated from the premises. Page number 42. Next, please.
Yes. Failing with the same. So when was this done? Notice got this was 3rd April.
I received this order on 10th April. I created a petition. I received.
Who you got this order? Why? How?
My name is the second 43, page 43.
Where is your name?
The legal heirs. They are the Karpaya expired. Now, my clients are the legal heirs of Karpaya. This is the Deep Narayan. Serial number 5, page number 43. Shyamlal Narayan Dutt, son of late Karpaya. Narayan Dutt, son of late Karpaya. They are legal heirs. My clients are not legal heirs. The Karpaya is no money, expired.
But whether no, what? When did you send the notice to the private respondent? You have not yet served.
Time, but I served the authorities. These are authorities. But now I find second appeal with secretary review also, along with the state petition. But yesterday I requested the secretary review to take up the matter since there's eviction order. But it's overloaded with administrative work. You can't take the matter. So how can I go?
He lacks jurisdiction, my lord. Second appeal,
How shall I go then?
Secretary Revenue lacks jurisdiction after passing one
But
judgment.
madam, what to do now? What to do now?
He has to file a second appeal before the Lieutenant Governor, not before the Secretary Revenue.
We are not, but he will be evicted. He was not a party now. The appeal court passed an order.
Fine.
Appeal was preferred by the private respondent without making the heirs of parties to it. But I am not in a position to know whether your heirs were there before. Huh?
Yes, private respondent is not before him, my lord. Then
Private respondent means?
Gyan Prakash Mishra.
No, on field report, unauthorized construction was alleged to have been done by Kurpaiya.
Yes. That is the complaint made by the
Land
private
is-
respondent. And private respondent today, my lord, is not appearing before my lord. Then how it be clear then? Whether notices were issued to them or not.
How can I,
That is different.
sir, if we,
I received the copy of 10th, purposely they have issued about 10th of April, my lord.
Mr. Kumar, how can I pass an interim order affecting a person who is not who is not has been served? Please try to
And
understand.
he is the complainant.
You do something.
But
Mr. Now, my problem is you are, can you show me that in RC case number 1088, you ARs were parties? RC was initiated on what basis?
on the complaint with the private respondent, he made a complaint.
Where is that complaint?
Complaint or not give copy to me, sir. Everything is illegal, not given the copy to me, not given the appeal copy to me, order has been passed against, I am not a party to the appeal.
You should have done something, you should have sent in by hand. You got it on 10th, you could have sent it, email you could have made, anything you could have done, some document at least.
No thing, my lord. Yesterday I went, serve the copy to the private respondent, he refused. And second, courier in local, nobody is accepting the.
So you show the refusal that you went to her.
refused.
How can I help you tell? He was the sole complainant, no?
Complaint. He was no complaint. He was not illegal. Ultimately illegal, Lord Ramadan.
Illegality will come later. Now, how will you save yourself? 15th April.
It's not that I did not prefer the appeal, I have preferred the appeal also. If authorities are not reading the matter, I give it, I got the copy of it. Preferred the appeal, that's it.
Preferred appeal,
Page 44, along with the state petition.
My lord, second revenue appeal, my lord, he has filed.
not maintainable, that is all right, but this was not taken up. You have served the appeal petition where? Show us that you service was complete upon this Shamlal Prem, upon this Gan Procas.
Second appeal also yesterday, he has filed. And audit application also filed.
Then go to file a petition before the appeal court. Before 15th.
Whole button with the administrative, they're not taking these matters at all, my lord. They're telling them meeting, they're telling like this.
He lacks
They're
jurisdiction.
telling meeting. That's why they go then.
Mr. You should have come to the right time. He is there, show me anything, I am considering the order.
Oh, this is the order of authority. I mean, the order for time limit, it's never given. At least one thing I can propose, my lord. That's done. Here the appeal. They have 5 days and ready for hearing the appeal. In the meantime, it is still in the meet. I'm ready for that.
See, come to page 36. So you were present before the sub-divisional officer?
One more thing, my lord, one more thing I want to say. But when it comes to order sheet of the sub-divisional officer, at page number, how they have done this thing, my lord, kindly.
What is your instruction, madam? You have got any instruction?
Cleverly they have done, my lord, kindly see. Page number 38.
Just
They have given the date to me. 26/3/25. Overwriting this date. They fix the date on 29th, the next party order will pass. 29th. Next page 29/3. They change the dates and pass the next party order. As if I was not present.
This is whose order?
As SDO, sub-divisional officer. Without the order, anything, the case is reserved for order ex party.
The cases?
Then,
Cases. Where have you stated this? This fact of day, where have you?
my lord. I will just.
Have you stated that anywhere?
Yes, I stated. Paragraph number 12, page number 8, I stated. That after registration of the first revenue appeal, the petitioner received a notice and a date of hearing of the appeal was 3/26/25, but later on, the third date has been changed without notice of petitioner and date was mentioned in the, it is mentioned. Order sheet 24/25, and the date could not be appeared.
No, the appeal was fixed on 26th March.
My lord, date was given to 26 March.
Then it was changed.
Changed to next date 29 confirmed they will do it. 24, next date 24. 24 to 25. They changed the date, 24 to 25.
On 15th March, she appeared and she prayed for time. My lord,
Yes, but
Page
but
15.
it was fixed, there is some interpolation.
Yes,
where?
they have changed the date, the last page.
Then 24/3 also the respondent not present and filed adjournment application. This is not the case that it is not within their knowledge that this proceeding was going on.
How could they do 38 page, the last
Yes,
page?
they were
But
they were
it
filing
was-
adjournment application, my lord, it is there.
you appeared on 24th, no?
In an adjournment application.
Thereafter, they've given me the date 5th of March, and after 5th of March, they told me next date is 24th, 26th March. They told me 26th March,
Hmm.
but they changed the date 24.
Then 24th, you were present.
They're not been filed and
Respondent not now.
not present and filed adjournment petition. And filed adjournment petition. The respondent not present and filed adjournment petition.
That's what was in past.
Why they're saying that they don't have the knowledge of that date when they have filed their adjournment application, my lord? It is there. They have
Now,
filed
how they are involved if they are the adjoining persons?
They claim to get they purchase the property. They're telling that they purchase land. Out of it's a huge chunk of land. Out of that 40 square meters under my occupancy, they're telling them.
How can I dispense with service and file?
Withdrawing of the decree.
If my lord sees the entire order sheet, my lord, revenue order sheet, it appears that time and again they will not appear, but they'll file their adjournment application. In that case, only the order was passed ex parte. It is there that,
But very good.
it is there that they have filed their adjournment application.
No, very good, but
Fine.
but if they have
Say that they don't have the knowledge.
right, we have understood your submission. Now, before the first revenue court,
My
you see that page 40, revenue first appeal is Tehsildar Shamlal. His name is not here.
whose name, Lord? Shamlal is the writ petitioner. Narayan.
Why you are-
Clear that all the.
Yes, then you were parties to the appeal. Why you are saying this?
Memo of it.
Page 40.
My lord. The order, they incorporated my name.
Here, all these things cannot be done. You were faster. Mr. Gold, you should not suppress this. You proceeded your argument saying that they have not implemented me and obtained that order. Kindly come to page 40.
Then
Yes.
respondents,
Beyond focus,
the appellant and the respondent.
servant.
Say that.
How am I to believe Mr. Kumar? The officer appeal, kindly come to page 40. You said I am not implicated in the appeal. Yes, you have shown me the petition. I don't know.
I think the order, I have my name, my lord. They can do everything, my lord. They can interpolate the date. Why not they add my name? They add my name. The certificate of the certificate will not be there.
First,
This is the, wait, this is the certified copy, page, page number 3, huh?
That's your signature is there, certified copy.
Yes, his name is not there, madam. Page 30 and page 40, his name is not there. In view of the urgency involved in the matter. check up the file. So please don't leave the premises. I will ask my court officer to call you. I am rising because there is a full court at 3:30. But please stay here. এই তুমি ওনার নাম্বার নিয়ে নাও তো আর ম্যাডামের নাম্বার নিয়ে নাও
Serial number 24.
Yes.
Will be go to the same that modification of the order.
This arbitration.
Yes, Your Honor. Arbitration, you want to change the arbitrator. The honorable justice Arbitrator has marked the order. Matter will be placed before the honorable justice.
No. That is not there. I can extend, it is change of arbitrator.
Yes. Change of arbitrator. We want for modification of the order, we're changing our arbitrator.
Modification of the order of,
Justice Arbitrator.
then why did you file it before me?
Fine here only, then it will be referred, that other matters are being referred. Registry will.
No, Mr. Khan, modification will be heard by the regular bench. If it is a recalling application,
Change of arbitrator.
so you check it up, today the matter is adjourned, you check it up and mention to his lordship online.
The registry will be directly to place before the honorable.
No, modification, why they will place? Modification will be before me, yes?
So the same thing.
You bring the list to the modification কি করে regular bench যাবে? Sir, you don't mention fag end of the time you come. Is there High Court list কি আছে? Combined list, High Court combined list. দেখি ফাইলটা বের করো তো। মডিফিকেশনটা কি রেগুলার বেঞ্চে যাবে?
Actually, 1-2 matter we have done. Chakravarti was opposing me and Chakravarti has filed. Even modification, we went to the same bench. Don't know what is.
Unless, my lord, it is something like an extension. Extension can be done by the circuit bench. But my lord,
Two division bench matter, my lord, I have done before, my lord justice decided over my lord justice Mosmi Bhattacharya and one my lord justice Anand said. For the division bench, administration has filed an application for modification, my lord, I was opposing.
Same principle.
Then,
Where is your application? Can one year file for what? For changing the arbitrator? And what is your main application about? Now that was appointed by virtue of. So that original order is over, original proceeding has been disposed of. Now you have come for modification.
Change of the arbitrator.
Can you do so? You have not termed it as a modification application also. For change of arbitrator. You are saying extension of time?
Change of arbitrator. That is modification of the order.
Have you served this application? No, sorry. No. Without hearing him, I cannot say. Without hearing him, this is a question of change of arbitrator, cancellation of mandate. You have made an application thereafter. Now you change. After the award, the parent order appointed him. Subject to correction, Mr. Khan, you have to apply your mind. What Mr. Kumar and Mr. Chakravarti is saying, that suppose I appoint arbitrator and his application for extension of the tenure of the arbitrator, that also will go to the regular bench, not to me.
Even this also will go to the same level. That is my respective submission.
But Mr. Khan, how will I know that? Because this application you serve and come.
I will, when the honorable told me direct, I will serve.
This is the.
Refer the matter to the The registry director registry placed before the evidence. Nothing more, you know. I don't require any more order.
But this, yes, Mr. Chakraborty, you can, if you can apprise us.
This I have doubt. my lord.
Your matter is,
That is not
why?
modification. Those are. Then what is?
Your modification, this is cancellation of mandate, change of arbitrator. It has to be heard by a regular way, Mr. Khan. We are having a similar matter which has been moved before me. Sorry, Mr. Khan, I'm sorry, but it is the. Serve it, I have not taken. Serve it. Serve it then now. All right, thank you.